We've had, many decades of Chevron doctrine being in place for regulations. What happens now?
Yeah, so legal experts are saying that regulators are going to be a lot more hesitant to pass any sort of regulations. And that's not a great thing for those of us that care about the environment and public health. And one of the main reasons they are going to be more hesitant is because this opens the door for industry groups and corporations to sue the agencies for their regulations, and also that these industry groups and these corporations can shop around for judges that align with their political beliefs. Do you want to talk a little bit about how this decision might impact industrial animal operations?
For the whole industrial meat world, it's kind of ironic because this is an industry, as we sort of document in our center here, that tends to be pretty lightly regulated. There are so many regulatory gaps, and these big meat companies are very powerful and very good at lobbying and gaining influence in these agencies like USDA, like EPA. And what this does is it takes an already bad situation and potentially makes it even worse. And there's one case that I've been looking at recently is the USDA. Back in the 2008 Farm Bill, the USDA was charged with coming up with rules to make a more fair situation for livestock farmers. And the idea is that livestock farmers work on contract with these big integrators, or big meat companies, and they have very little power. The big companies dictate to them, how they can grow their stuff, how they can grow their animals. They, basically capture most of the profits in it. They have them competing against each other to maximize the company's own profits. And so there's been a lot of pushback against this, and it's been an incredibly vexed process. Congress since then has nullified it a couple times in later farm bills, and finally this year, 2024, so almost 2 decades later, the USDA comes out with a new set of rules that are pretty well liked by some of the advocates in the space. And the meat industry is already celebrating and sort of rubbing its hands together. There was a statement in Politico from a meat industry trade group saying, oh, yeah, we're definitely thinking about using the collapse of Chevron in court cases. And another one that we've been looking at is the Environmental Protection Agency, the EPA. And a similar thing has finally come up with a draft rule about regulating pollution from these CAFOs, from these giant industrial farms under the Clean Water Act, which has been an incredibly vexed process. The Clean Water Act is from the early 70s, and they're just now figuring out rules that would bind these giant operations to document their pollution, to limit their pollution. And once again, this is just about to happen, and it's very inconvenient that that Chevron doctrine falls, because that's going to give the industry space to challenge that in court. And like you said earlier, shop for a nice federal judge somewhere. And if they lose that case, they know they've got the Supreme Court back there ready to do their bidding. Another one, getting a little bit off the animal agriculture topic. The EPA just a few months ago came out with new rules regulating PFAS, which are these so-called forever chemicals that are ubiquitous in the United States. They're in our water, they're in our bodies, and the EPA had no limit on PFAS in water. And there's been documented cases all across the country of water systems where people are getting PFAS in their drinking water. And the EPA came out with a rule limiting that, putting a limit on it that's going to cause all kinds of action. Water agencies across the country who have PFAS in their water supply are going to have to figure out how to filter it out. It's a really big deal. And also it could be a boon for public health. PFAS have been tied to lots of different cancers. And this gives the chemical companies that have put this stuff out a very nice way to challenge this rule and take a lot of pressure off of themselves. Now, you've been looking a little bit into what the response could be from Congress to take back some of this power from the judiciary and give it back to the agencies. Talk a little bit about that.
Yeah, so when the Supreme Court made this decision in Loper Bright, they used statutory law and not constitutional law. So that means that Congress could pass a statute to enshrine the Chevron deference doctrine into law. And so they could do that in two ways. They could do that kind of when they are passing legislation on a particular topic, like clean water or clean air. They can direct the regulators and say regulators could, where you can use the Chevron deference doctrine here, or they could kind of in one fell swoop and codify Chevron deference into law. And actually, just last week, Senator Warren and some of her allies introduced the Stop Corporate Capture Act, which would do just that, though we don't expect it to pass the Republican-controlled House.
And so here we are right before the election, and we're about to get a new Congress and a new president, and who knows what's going to happen next. But one thing you can count on is that CLF will be watching and reporting on this.